session. First of all, we will revise what we have learned earlier. Can anyone tell me about section 8?
Ma'am, it is about statement and undertaking regarding foreign application.
Correct. Which form is required for that?
Ma'am, Form 3.
Okay, and fees and timeline?
Fees for no fees is there, ma'am.
Correct. And timeline?
Within 6 months.
From the date of the filing of your application.
Application, right, ma'am.
Okay.
Yes, ma'am.
Correct. What is section 9?
Ma'am, it is about provisional and complete specification.
Correct. And what is its ground? मैं आपको क्वेश्चन करती हूँ. Provisional after filing a provisional application, what is the timeline for CS?
Within 12 months.
Okay.
Within
and
12 months we have to file
you
the
can
CS.
You can extend the timeline
For 3 months.
3 months, yeah.
No.
No,
6 months, ma'am.
for 6 months.
6
6
months. ma'am.
months. 6 months.
Yes, ma'am. 6 months. Yes.
You can extend the timeline for the 6 months.
Yes.
That
ma'am.
is the post date your application.
Yes, ma'am.
Correct. And the 3 months timeline is called the FER.
Yes.
You will get the 6 months of time, and further you will get 3 months of time to
Yes.
extend that. Now, what is section 3?
Section
3.
3.
Hmm.
Ma'am, not patentable
Inventions, not
invention.
patentable.
Patentable inventions.
Okay. So A से लेके P ground सबको याद है? Everyone is remember?
Yes,
कुछ
ma'am.
याद है, मैम.
नहीं चलेगा.
एक बार पूछ लीजिए मैम आप.
ठीक है, चलिए. 3E.
3E.
Admixtures is related, ma'am.
Yes, ma'am.
Correct. It is related to admixture.
Mere
But
admixtures.
or aggregation of properties.
हाँ, ये नहीं चलेगा. You have to remember the sections daily. मैं आपको mention करती हूँ section 3. उसके बाद आएगा आपका opposition grounds and revocation grounds, compulsory license के grounds. ये चीजें आपको डेली रिवाइज करनी पड़ेगी. आपका डेस्कबोर्ड आपका जो भी वर्क स्टेशन है उस पे प्रिंट आउट लगा के लगा दीजिए. दिस आई हैव टू रिमेम्बर डेली. ठीक है.
Okay, ma'am.
Done. What is the definition of inventive steps? Invention definition.
Invention.
Invention means something
novel and then capable
No.
of producing industrial
And
applications.
having inventive step and
Industrial application.
industrial application. Capability of industrial application.
It
Three
should be
criteria.
novel. It should be
Novel.
novel and inventive step, and it's capable of industrial application.
Correct. And what is inventive steps?
Inventive step means that technical advancement to the existing knowledge, or it should have economic significance, or both.
Correct. Done. Now what is section 13?
Related to anticipation.
Correct. आपको,
And round 1 basically deals with that if the claim of a applicant's complete specification is similar to the claims of any complete specification which is filed before the date of priority date of applicant's complete specification, then it will be considered as a prior art.
excepting certain cases like the inventive steps invention has publicly displayed, and within 12 months application has been made, and if it is submitted to government for secrecy revocations and secrecy directions and other things, so this should not be considered as a prior art.
Prior art और है ना anticipation में consider नहीं होगा वो. Correct. Okay, now we'll begin with the today's session. That is section 17, power of controller to make order respecting dating of application. So in which the subsection 1 says about you have filed your application under section 9, that is prior provisional application followed by the complete application. In case you are unable to file a complete specification within 12 months of time that is already described, right? In that case, you can post date your application by 6 months with the request to the controller.
Ma'am, with form 30?
Form 30, with the form 30 and section 17.
Okay, ma'am. Ma'am, is there any fee for this
Yes.
process?
Yes, there is a fees mentioned. I have to check that fees. I think it's 800 rupees
Okay. For post dating.
for the post dating.
Okay.
1800 rupees for
1800, sorry, 1800 for the natural person. I will cross check the fees again and I will tell you.
Okay, ma'am.
Okay. Okay. Right. So you understand the post dating कि आपको post dating कब हो सकता है at the time when you are unable to file your complete application within a 12 months of prescribed time, right? At that time your priority date will be shifted. जितना time में आपने post date किया है, suppose you have post date your application by 3 months, so your priority date will shifted. Suppose you have applied in patent in January. Now you have to post date your application in a March. You need 3 months of time to file a complete application. So that is from the March, right? So at that time, your priority date, that is earlier it's a January. Now your next priority date is post date, like extended, that is in the March. Post dating questions आपके MCQs में आते हैं. They give you a certain conditions or situations कि ये application है तो what is my new priority date. अभी
excuse me ma'am, sorry to interrupt. Ma'am, जो ये post dating है वो जो हमने application file की है उससे 6 month होगा ना?
हाँ 6 मतलब आप 1 महीना भी कर सकते हो, 2 महीना भी कर सकते हो, 6 months तक कर सकते हो. That is the maximum timeline is 6 months.
अच्छा.
So they have mentioned that a date later than 6 months from the date of the actual filing. मतलब उससे ज्यादा आप नहीं कर सकते, आप 6 months तक extend कर सकते हो.
Means 18 month तक हम कर सकते हैं उसे.
नहीं ऐसे
12
plus 6 हाँ ideally for our calculation is at 18 months you can file a complete application, but in the actual scenario your priority date will be shifted if you are post dated, so the timeline remains the 12 months only. Okay.
मैम थोड़ा ये क्लियर नहीं हुआ है पॉइंट.
क्लियर नहीं हुआ है. आइडियली हम देखें जैसे आपने 1 जनवरी आपने आज एप्लीकेशन फाइल की है, 1 जनवरी 2021 में फाइल की थी. आइडियली यू हैव टू फाइल एट CS ऑन 1 जनवरी 2022, राइट? अभी मैं ड्यू टू सम सिचुएशन आई एम नॉट अनेबल टू फाइल माय एप्लीकेशन. एट दैट टाइम मैंने 6 months का एक्सटेंशन ले लिया, सो मैं जून तक फाइल कर सकती हूँ ये एप्लीकेशन. For me, I get a time of next again 6 months, but my priority date will be shifted from the 1st January 2021 to 1st June 2021. So
got it.
for me, I get a next 6 months time, but for my application, my timeline remains at 12 months only. Got it?
मैम आई हैव अ क्वेश्चन कि उस 6 months पीरियड में अगर कोई एप्लीकेशन रिलेटेड टू सेम इन्वेंशन पब्लिश हो गई तो वो प्रायर आर्ट कंसिडर होगा उस एप्लीकेशन, तो मैम ये डिसएडवांटेज होगा?
यस।
तो मतलब अगर किसी को पोस्ट डेट करना है सो वी हैव टू लुक कि उतने टाइम में कोई प्रायर आर्ट नहीं है,
वो भी चेक करना पड़ेगा, या तो फिर आपको ये भी चेक करना पड़ता है इसमें कि आपका जितना टाइम चाहिए आपको उतने टाइम ही आप उसको पोस्ट डेट करो, बिकॉज मुझे पता है कि आई कैन अप्लाई फॉर द पेटेंट CS इन विद इन 1 month, मेरा कंप्लीट हो जाएगा। सो आइडियली टेक ओनली 1 month एक्सटेंशन।
ओके मैम।
अभी मैं आपको एक सिचुएशन बताती हूँ। सपोज मैंने फाइल की एप्लीकेशन 1 जनवरी 2021 को, तो मेरी CS मुझे कब तक फाइल करनी पड़ेगी? आइडियल 12 months।
12 months, yeah.
So what would be the date? My last date for filing this application?
31st December 2021.
No, this is the misconception.
Patent 1st January 2022.
करेक्ट। पेटेंट ऑफिस जिस डेट पे आपने फाइल की है वही डेट को कंसिडर करेंगे 12 months के लिए और द 6 months के लिए। सो उसके एक डेट बिफोर भी नहीं होगा, एक डेट आफ्टर भी नहीं होगा।
ओके,
ठीक है, ये आप मेंशन कर दीजिए, बिकॉज इन द MCQs क्वेश्चन दे हैव मेंशन लाइक कंफ्यूजिंग डेट्स लाइक दिस। सो रिमेंबर दिस थिंग्स क्लियरली, you have to 12 months from your date of filing. So simply change the
to request for post dating. Okay. To request for post dating, we should have to make the request to the controller within the 12 months time period, or if we cross the 12 months time period also, we can make the request to post dating our application to get the extra time to file the complete specification.
Not within the 12 months. Like if your 12 months is completed on the 1st January 2022, so you have to make request on 31st, before the 31st or on the 31st. You cannot make request on the same date. Preferably before the 10 days.
Suppose the time has passed, it lapsed, 12 months has lapsed. You want to request means you have to apply a fresh.
Yes, you have to apply for the next fresh application, because if your 12 months time is completed, then your application is automatically abandoned.
Okay, ma'am.
Okay, right. So we'll go through the section. Power of controller to make the orders respecting dating of the application. The subsection 1 says that, subject to the provision of section 9 that we have discussed, at any time after the filing of an application and before the grant of the patent under this act, the controller may, at the request of the applicant made in the prescribed manner, direct that the application shall be post dated to such date as may be specified in the request, and proceed with the application accordingly, provided that no application shall be post dated under this section to a date later than 6 months from the date on which it was actually made or would, but the provision of this subsection be deemed to have been made. Right, so you can post date your application by 6 months. Remember one thing, the timeline which I have mentioned in the section, that cannot be extended. Rules timelines can be extended, but sections timeline cannot be extended.
मैम इसी से कोरिलेटिंग हमने सेक्शन 9 सबसेक्शन 4 में पढ़ा था कि हम प्रोविजनल एप्लीकेशन फाइल की और कंप्लीट स्पेसिफिकेशन फाइल कर दी, बाद में हमने वो जो प्रोविजनल स्पेसिफिकेशन है उसे कैंसिल कर दिया टू द डेट ऑफ फाइलिंग ऑफ कंप्लीट स्पेसिफिकेशन। तो मैम सपोजिंगली अगर हमने फाइल किया प्रोविजनल स्पेसिफिकेशन एंड 7th मंथ में हमने कंप्लीट स्पेसिफिकेशन फाइल की और हम उसी 8th मंथ में हम रिक्वेस्ट कर रहे हैं टू कैंसिल द प्रोविजनल स्पेसिफिकेशन टू द okay, we are requesting to cancel the provisional specification to the date of filing of complete specification. So will it be allowed like वो 6 month period gap इसमें matter नहीं करेगा?
आपकी जो प्रायोरिटी डेट है वो पोस्ट डेट हो जाएगी, फ्रॉम द डेट ऑफ फाइलिंग हो जाएगी इफ यू कैंसिल योर प्रोविजनल एप्लीकेशन.
Okay, so in this case section 9 subsection 4 the window period of 6 months is not applicable, like we can,
because you have already applied for the complete application, na?
Okay.
Right. This is talking about if you are not able to file PS after CS.
Okay, all right.
Then only you can get a 6 months of extension. Okay.
Okay, thank you, ma'am.
Now the subsection 2 says that this is talking about the amendments. If you are amended your application, so during the amendment you have mentioned the maybe some important technical things. So the date of your amended specification will be considered, or the matter you have disclosed in the amendment, that will be considered. Now the subsection 2 says, where an application or specification or any other document is required to be amended under section 15, the application or specification or other document shall, if the controller so direct, be deemed to have been made on the date on which the requirement is complied with, or where the application or specification or other document is returned to the applicant on the date on which it is refiled after complying with the requirements. What section 15 says that you can amend your application based on the controller's guideline. If you have to rectify your application to enhance your technical features, or any complete specification or any claims to overcome the objection raised in the FER or maybe the direction of the controller. So at that time, you have refiled your application after the drafting. So the amended the date of the amendment will be considered for that particular claim or particular specification. Okay. Now the section 18 talks about power of controller in case of anticipation. We have discussed the anticipation in section 13. That shows that if the article or a complete specification that is published before the priority date of your application, then आप उसको कैसे consider करोगे anticipation में है कि नहीं. So in that case, one scenario is that you have done a prior art search before filing your application. Let's say I have done a prior art search in the December for filing application in the January, but at that time the application is not published, or that particular specification is not published in the any journal or somewhere, because the 18 months of time period is not completed, right? And after that you have applied for the application, because you will not get the similar prior art or cited similar documents. So in that case, आप जब एप्लीकेशन फाइल करोगे आपको प्रायर आर्ट नहीं मिला है, बट जब आपकी एप्लीकेशन पब्लिश होगी और एग्जामिनेशन में जाएगी, एट दैट टाइम द पर्टिकुलर प्रायर आर्ट व्हिच हैव पब्लिश्ड आफ्टर योर फाइलिंग ऑफ योर एप्लीकेशन, सो उसको कंसिडर नहीं करेंगे एंटिसिपेशन में, बिकॉज यू आर नॉट अवेयर ऑफ दैट पब्लिकेशन. और द सेकेंडली कंट्रोलर आपको
समझा दीजिए. आई एम अनेबल टू अंडरस्टैंड, कैन यू प्लीज रिपीट इट अगेन?
Sure. Suppose you have done a prior art search before filing of your application, but after completion of your prior art search, you have applied for the patent, right? Now your patent is published, and during the examination, the cited documents or the prior art documents cited by the controllers. Okay, look, this is the prior art, right? But आपको तो वो prior art मिला नहीं था during your search, because that particular prior art is not published at that time, so you will not get at the time of filing your application. So that particular prior art will not considered as a cited document, or it cannot be anticipated in your application directly.
So in this case, suppose another publication appeared in other journals or patent anywhere in the world, then will not be considered. It means it will be the controversial.
करेक्ट. सो उसको कंट्रोवर्सी क्रिएट कर रहा है यहाँ पे, बिकॉज आपको पता ही नहीं था, यू आर अनअवेयर अबाउट दैट पर्टिकुलर आर्टिकल्स, बिकॉज दैट इज नॉट पब्लिश्ड बिफोर योर फाइलिंग ऑफ योर डेट.
So in this case, the who will be the first, who will be the adhere the first of the prior art?
So in that case, जो प्रायोरिटी डेट है, जो फर्स्ट फाइलिंग, जो इसने फर्स्ट फाइल किया है, उसकी रहेगी.
Suppose ma'am, in the same time, within the period of the time, six people they filed the patent in all over the world. And during this time, then controller किसको पहले प्रायोरिटी देगा बाद इस ड्यूरेशन में?
So date of filing
छह लोगों ने डाल दी है एप्लीकेशन.
डेट ऑफ फाइलिंग चेक की जाएगी.
क्योंकि ये पीसीटी में नहीं गई है, ये नॉर्मल एप्लीकेशन गई है, पीसीटी में गई नहीं है, तो अब हम ऑल ओवर वर्ल्ड को तो कंसीडर कर ही नहीं सकते हैं.
जिसने फर्स्ट फाइल की होगी
तो सेम डे को एक ही ड्रग 6 लोगों ने फाइल कर दी. सपोज कर लिए एंटी मलेरियल एक ड्रग है और उस पे काम चल रहा है, और 6 लोगों ने सेम डेट को वर्ल्ड में अलग अलग जगह फाइल कर दी.
करेक्ट. अब एट दैट टाइम डेट ऑफ फाइलिंग चेक की जाएगी. डेट ऑफ फाइलिंग सेम डेट है तो डेट ऑफ टाइम चेक किया जाएगा, राइट? और इन दैट सिनेरियो जो कॉन्फ्लिक्ट क्रिएट हुआ है, एट दैट टाइम कंट्रोलर चेक करेंगे कि यू हैव टू, मतलब जिसने अप्लाई की है उसको उसका पूरा लैब रिकॉर्ड से लेके सारी चीजें कंट्रोलर को दिखानी पड़ेगी. सी आई हैव वर्किंग ऑन द सिमिलर ड्रग since this much of time, and now I found that I can able to apply for the patent, so I have applied. So in that case, reasonable grounds is important.
Madam, may I interfere just a moment? Dr. Geetanjali, suppose you are making a process for making anti-malarial drug,
right?
The process may be different, the product composition may be different. Elsewhere, right, the inventions are happening simultaneously. Elsewhere, they are applying for the patent. First, everything will be on par, will be evaluated. Then only whether the prior art will be considered or not. If the process is entirely different and the composition is entirely different, then it is independent of whether everybody has been filed on the same date or not.
Suppose the structure is the same and the process of the making the structure is different. Yes. And activity is the same, the criteria is also same. In that case, what will happen?
In that case, what happens, which is the one which is showing the definite inventive step, that will be considered.
Minimum inventive steps, or what, the easy process, economic process, which one will be considered?
Definite inventive step which has an edge over others.
Suppose in the duration of this time, one publication is appeared in public domain, means the journal, not in the patent.
Okay.
So in this case, what they will do?
In that case,
okay, madam, go ahead. Please go ahead.
In that case, you have to amend your application by and mentioning the reference of the particular publication in your application. And you have to also show the reasonable grounds, like my application is different than the published article.
Exactly.
Okay.
Right.
Means we have to justify that
Yes.
how much it is economically or significant.
Yes.
Okay.
You have to justify your application.
Okay.
This is in response to the examination report and the opposition from the controller.
Correct. In these two scenarios.
Okay. Thank
Okay.
you, ma'am.
Yeah.
So feel that there are a similar kind of inactions because so the better always thing is to go for early publication, to go for expediting of your examination of the application. So in that way, the controller will give the grant of your application as early as possible.
Yes. So it is always advisable to go for the publication, but in some of the scenario, you have to check whether your invention is that much effective or not.
Correct.
At that time, you will go for the early publication. So we have discussed in the last class also, your rights of your claiming the damages will start from the date of publication, not from the date of filing. So it is better that your application will be in the public domain. But in some of the cases, there is a risk to show the process, you hold the process to the world. Yeah, I'm doing this invention by using this process. So this varies from the case to case. कि आपको किस application में early publication में जाना है कि नहीं जाना है.
So this is section 18(1) subsection says that because I am not anticipating the say similar application which is submitted to the patent office because it's under the publication of 18 months time period, because at that time I could not able to anticipate it. This prior art may come in my search, but examiner will consider that prior art, that application as a prior art.
Correct. मतलब यही होगा कि मुझे पता ही नहीं था at the time of my priority search I am not
aware of
the कि ये application भी है, because it is not in the public domain.
Correct.
So at that time you have to prove the justification, like this is before the publication I have applied for the patent. That is your first ground. And secondly, if the similar process is mentioned in the both your invention, at that time you have justified your process, how your process is different, or in somewhere like कि आपका जो application है उसमें technical enhancement कितना है as compared to the earlier application.
Understand.
और in some of the cases controller guide करेंगे कि आपको इसको amend करना पड़ेगा to get a grant of your patent.
Okay. At the time if the two patent applications are hitted, and we have to look at the priority dates of the same two applications and the time of the applications, and if at all those are also get matched, and we have to go to the technical details of the invention to see the differential aspect in the terms of product as well as the process, how it will be different, and to get the efficacy or increase or improvement of the invention.
Correct. Just right. So yes, question. Any question? No. So subsection 1 we have discussed. Subsection 1 कि आपकी priority date से पहले it shows the satisfaction of the controller that the priority date of your claim of this complete specification is not later than the date on which the relevant document was published, right? And the B says that amend his application to the satisfaction of the controller. Now subsection 2 is talking about you have to mention the reference, that is a reference number in your application. कि अगर suppose कुछ publication भी है and at a time of getting at a time of priority search you will come up with the certain documents that you may feel that this is relevant to my application. At that time you have to mention that particular reference number in your specification. Now the question comes कि आपको ये reference number कहाँ पे mention करना है? After the background of your invention, you have to mention the particular reference numbers. Look, this is the application or this publication is relevant to my document, but what is the difference or the technical enhancement, that also you have to mention. So if it appears to the controller that the invention is claimed in a claim of any other complete specification referred to in clause B of subsection 1 of section 13, he may, subject to the provisions hereinafter contained, direct that a reference to that other specification shall be inserted by way of notice to the public in the applicant's complete specification, unless within such time as may be prescribed. The applicant, the ground says that the applicant shows the satisfaction of the controller that the priority date of his claim is not later than the priority date of the claim of the said other specification, or the complete specification is amended to the satisfaction of the controller. Now the 3 is talking about the same, that if it appears to the controller as a result of an investigation under section 13, कि जब भी एग्जामिनेशन रिपोर्ट आया और कंट्रोलर को ये इन्वेस्टिगेशन के बाद रिजल्ट मिला that the invention so far as claimed in any claim of the applicant's complete specification has been claimed in any other complete specification referred to the clause A of subsection 1 of section 13. And B says that such other complete specification was published on or after the priority date of the applicant's claim. जो हमने बात किया कि 18 months publication होने से पहले ही हमने फाइल कर दिया था किसी और की एप्लीकेशन that is similar to our invention. Then unless it is shows to the satisfaction of the controller that the priority date of applicant's claim is not later than the priority date of the claim of the that specification, the provision of the subsection 2 shall apply thereto in the same manner as they apply to the specification published on or after the date of the application of the applicant's complete specification. So basically जो anticipation है, that is talking about the similar thing, कि आपका किसी पब्लिकेशन में नहीं होना चाहिए, पब्लिकेशन में होगा तो एट दैट टाइम यू हैव टू मेंशन, उसके बाद अगर कोई क्लेम कर रहा है एप्लीकेशन का, सो एट दैट टाइम यू हैव टू ऐड दैट रेफरेंस इन योर स्पेसिफिकेशन. नाउ एट अ टाइम ऑफ द इन्वेस्टिगेशन, दैट इज इन द FER और एट अ टाइम ऑफ हियरिंग, जो इन्वेस्टिगेशन होता है, सर्च होता है, जो कंट्रोलर चेक करते हैं, एट दैट टाइम उनको कुछ मिला कि this invention is similar to your application, at that time they will check the priority date and the prior art. Okay, now the 4 is the omitted. Now the power of controller in case of potential infringement. The subsection 1 of the section 19 says that the consequences of the investigation required under this act, it appears to the controller that an invention in respect of which an application for a patent has been made cannot be performed without substantial risk of infringement of a claim of any other patent. He may direct that a reference to that other patent shall be inserted in the applicant's complete specification by way of notice to the public, unless within such time as may be prescribed. आपका जो भी एप्लीकेशन नंबर है, इफ यू फील दैट कि दिस इज सिमिलर टू माय एप्लीकेशन, कि ये इंफ्रिंजमेंट में you found some similarities in your invention and the other documents. So at that time you have to add the reference in your specification and stating that your application, how your application is different than the existing complete application. and how my claims are valid as compared to the prior art. A says that the applicant shows to the satisfaction of the controller that there are reasonable grounds for contesting the validity of the shared claim of the other patent. And B says that the complete specification is amended to the satisfaction of the controller. Now you have to make the reasonable grounds how your invention is different than the particular application, or for the satisfaction of the controller you have to amend your application.
Means, ma'am, it is unable to understand. Can you please elaborate this, please?
Suppose at a time of infringement हम क्या चेक करते हैं? We are checking the claims. अभी in some of the patent you will find the similar claims in the other patent as the same of your application. Correct?
Correct.
So in that case आपको क्या करना पड़ेगा? आपका उसका reference number you have to mention in your application कि मैं ये particular application that is already published or granted application, right? So ये application के जो भी claims है उससे मेरे claims से वो different है. So you have to make a reasonable grounds for contesting the validity of your claim. At that time you will not potentially infringed, or the infringement of your application is substantially low.
Okay. Okay.
Hope you understand this point.
Yes, ma'am.
Ma'am, how is it different from section 18?
Can you explain by an example?
See, section 18 में जो भी है वो publication है और priority date claims है, whether the patent is granted or the published. आपका जो 18 section जो है anticipation by the anyway, right? But here the infringement comes at that time only granted patents will be considered.
Yeah.
Okay.
Correct. So that is a basic difference between the 18 and 19. 19 में आपका कोई भी prior publication, published application or a granted application can be considered. But in the potential infringement, only granted claims are considered.
Okay.
So the 19 subsection 1 is clear?
Yes, ma'am.
Yes. Okay. Now, second says that whereafter a reference to another patent has been inserted in the complete specification in pursuance of a direction under subsection 1, कि आपने कुछ भी मेंशन किया है आपकी एप्लीकेशन में कोई भी रेफरेंस नंबर कि दिस इज द ग्रांटेड एप्लीकेशन एंड with the reasonable grounds this is different from my invention. At that time there is a 3 scenarios कि वो infringement में consider नहीं करेंगे directly. Other patent is revoked or otherwise ceased to be in a force कि वो application exist ही नहीं कर रही है due to some reason it is revoked or prior annuity fees pay नहीं की है तो वो seize हो गई है. So in that case वो infringement नहीं count होगा. B says that the specification of that other patent is amended by the deletion of the relevant claim. In the particular specification में चीजें mention की हुई है, but in the the claims are amended or the deleted, which mention the similar to your invention. At that time वो infringement consider नहीं करेंगे. C says that it is found in the proceeding before the court or the controller that the relevant claims of that other patent is invalid or is not infringed by any other working of the applicant's invention. The controller may on the application of the applicant delete the reference to that other patent. So in that case जो आपने reference number mention किया है in your application but आप ये पर्टिकुलर एप्लीकेशन के लिए ऑलरेडी कोर्ट में कोई केसेस हुए हैं, इंफ्रिंजमेंट केस हो या कोई भी केस हो, और एट दैट टाइम कोर्ट का एक डिसीजन है कि आप ये जो पर्टिकुलर पेटेंट एप्लीकेशन है फॉर द सपोज दैट एप्लीकेशन इज रिलेटेड टू प्रोसेस, सो कोर्ट ने डिसीजन दिया है कि ऐसी प्रोसेस होगी किसी भी और एप्लीकेशन में, तो वो ये पर्टिकुलर एप्लीकेशन को इन्फ्रिंज नहीं करेंगे. सो इन दैट बट यू आर अनअवेयर ऑफ दिस, this is the litigation going on for this application, and you have mentioned the reference in your application regarding that particular patent, right? So at that time controller will direct you that delete the reference of the other patent from your specification. Okay, so you have to remember this grounds also. In which scenario potential infringement will not be considered.
One small question here.
Yes.
Why do I insert or intimate or inform to the controller to giving the hint or make sure that reduce his work to identify the relevant prior art with respect to the infringement aspect?
So इसमें दो चीजें रहती है कि you have mentioned the particular reference number in your specification. That means you are aware of the application, what is existed in the before the priority date of your application. The particular process or a product is existed, you are aware of, but then also you have applied for a patent. You can prove over that कि मुझे ये चीज पता है कि existing knowledge है, but my application has a technical enhancement as compared to the existing knowledge. So you will get the benefit over that.
Okay.
So that is the reason you have it is better to insert if आपको पता है कि ऐसा कुछ available है, so it is advisable to insert that application number.
Madam, this is applicable for modification of existing inventions, right?
Yes. Existing invention modification, हाँ, मतलब you can say the like suppose for example one type of fabric is available in the market, but now आप उसकी composition change कर रहे हो वो fabric की to get a antiviral effect or antibacterial effect, उस पे कुछ coating करके. Fabric is already available, fabric is already known, that is a cotton fabric, well known from the industry, right? Now you are
dust proof or dust proof? Dust proof or dust proof?
Dust proof, yeah, dust proof fabric, right? So you are just doing a coating on the fabric. So you can mention that I have taken this fabric that is already patented, and now I am doing the coating over that by using the particular composition. So I am not claiming the fabric, I am claiming my composition, but I am claiming the product also, because by using the existing fabric, I will get the result. Correct. At that time, you have to mention the reference number of the particular patent.
Improvisation. That is rather improvisation.
Improvisation. Correct. Improvisation.
Okay, madam. Okay, madam.
Okay.
Thank you.
Okay. Now, the power 20 says that power of controller to make orders regarding substitution of applicants. अभी मैंने कोई एप्लीकेशन फाइल कर दी, आई हैव अप्लाइड फॉर पेटेंट, उसमें मेरे जॉइंट एप्लीकेंट्स है कि दो एप्लीकेंट ने हमने साथ में एप्लीकेशन फाइल की है. अभी आपका कोई फ्रेंड आ रहा है आपके पास कि मैंने भी इसमें काम किया है, तो मेरा भी नाम, मुझे इसका शेयर चाहिए या मुझे भी इसमें ऐड होना है फॉर द पर्टिकुलर एज ए एप्लीकेंट, कि मैंने भी इस पे काम किया है या फिर आई हैव फाइनेंशियली मैंने ये दिया है आपको स्पॉन्सर, मैंने स्पॉन्सर किया ये एप्लीकेशन को और पर्टिकुलर प्रोडक्ट को, सो मेरा भी नाम इसमें आना चाहिए. तो एट दैट टाइम आप क्या करेंगे, to add the one more applicant before the grant of the patent, you have to file form 6 for that, and the fees for the form 6 is Form 6 fees is 800 rupees. To add or substitute, you can say substitute the name of the other applicant. Check the one by one. So first says that if the controller is satisfied on a claim made in the prescribed manner at any time before a patent has been granted. Remember these things: before a patent has been granted, that by virtue of an assignment or agreement in writing made by the applicant or one of the applicants of the patent, or by operation of law, the claimant would, if the patent were then granted, be entitled thereto, or to the interest of the applicant therein, or to an undivided share of the patent or of the interest. The controller may, subject to the provision of this specific section, direct that the applicant shall proceed in the name of the claimant or in the names of the claimants and the applicant or the other joint applicant or applicants accordingly as the case may require. So before the grant of the patent, you can add or substitute the name of the applicant by the assignments or the agreements.
Madam, this statement is making our head swirling, madam.
Sorry?
The statement is so long that if I start from the one to end at the other, everything bhul jata.
So you have to remember only one point. Before the grant of patent, you can add or substitute any applicant's name by virtue of an assignment or the agreement that you have to made in the writing. आपने कोई स्टैम्प पेपर पे एग्रीमेंट कर लिया कि ओके आई एम ओके कि आपका नाम भी मेरे साथ ऐड हो रहा है, या तो फिर किसी एक का नाम सब्स्टिट्यूट कर रहा है, ठीक है? So you have to remember this part only. This is the crux of the subsection 1.
Okay, madam. Thank you.
Now the 2 says that कि आप जो भी कर रहे हो, तो if you are substituting the name any of the applicant or the adding the any of the applicant, at that time जितने भी applicants है, joint applicants है, उनके consent होना जरूरी है. So no such direction as aforesaid shall be given by virtue of any assignments or agreement made by one of 2 or more joint applicants for a patent, except with the consent of other joint applicant or applicants. Without consent of all the applicants, you cannot add any name. Otherwise, वो dispute create हो जाएगा. Now the next says that no such direction as aforesaid shall be given by virtue of any assignment or agreement for the assignments of the benefit of an invention unless the invention is identified therein by reference to the number of the application for the patent. जब आप एग्रीमेंट कर रहे हो तो उसमें आपको एप्लीकेशन नंबर मेंशन करना पड़ेगा. There is produced to the controller an acknowledgement by the person by whom the assignments or agreement was made that the assignment or agreement relates to the invention in respect of which that application is made. कोई भी असाइनमेंट और एग्रीमेंट के साथ ही आप किसी का नाम सब्स्टिट्यूट कर सकते हो. और इफ यू हैव earlier you have submit any assignment or deed of assignment and form 1, so you have to revise that too. You have to file revised forms also along with the existing assignments. The rights of the C says that the rights of the claimants in respect of the invention have been finally established by the decision of a court. कोर्ट के डिसीजन के बाद अगर कोई डिस्प्यूट हुआ है तो एट दैट टाइम राइट्स जो है वो कोर्ट के डिसीजन के बाद फाइनल गिने जाएंगे जो कोर्ट ने डिसीजन दिया है. द कंट्रोलर गिव्स डायरेक्शन फॉर एनेबलिंग द एप्लीकेशन टू प्रोसीड or for regulating the manner in which it should be proceeded with subsection 5. हम subsection 5 जो है वो dispute के बारे में बात कर रहा है, वो हम आगे देखते हैं. हाँ, अब 4 says that कि अगर आपका if there is a 2 or more joint applicants, उसमें से any of the applicant is died, so at that time who will own the application, और किसका नाम ऐड होगा, और who will the representative of that particular application. This is before the grant, right? Where one of 2 or more joint applicants for a patent dies at any time before the grant of the patent, the controller may, upon a request in that behalf made by the survivor or survivors, and with the consent of the legal representative of the deceased, direct that the application shall proceed in the name of the survivor or survivors alone. So इसमें ये इसकी एप्लीकेशन कैसे होगी कि आपका जो भी जॉइंट एप्लीकेंट प्रेजेंट नहीं है वो दे आर डाइज, राइट? सो एट दैट टाइम द लीगल रिप्रेजेंटेटिव जो भी होगा उनको डेथ सर्टिफिकेट देना पड़ेगा, और द लेटर ऑफ एडमिनिस्ट्रेशन इन रिस्पेक्ट ऑफ हिज एस्टेट दे हैव टू प्रोवाइड एनी डॉक्यूमेंट दैट गिव्स कंसेंट टू द लीगल रिप्रेजेंटेटिव. उनको ये चीज दिखानी पड़ेगी, देन ओनली द नेम इज सब्स्टिट्यूटेड इन द नेम ऑफ द सर्वाइवर और सर्वाइवर्स. नाउ द 5 says that if any dispute arises between joint applicants for a patent, whether or in what manner the application should be proceeded with, the controller may, upon application made to him in the prescribed manner by any of the parties, and after giving to all parties concerned an opportunity to be heard, give such direction as he thinks fit for enabling the application to proceed in the name of one or more of the parties alone, or for regulating the manner in which it should be proceeded with, or both those purposes as the case may require. So in case of any disputes, so जो कोर्ट का डिसीजन होगा या कंट्रोलर जो डिसीजन देंगे कि किस पार्टी के पास है ये चीज, आफ्टर द हियरिंग ऑफ द ईच पार्टी, कि जो भी इक्वल एंड अनडिवाइडेड शेयर ऑफ द पर्टिकुलर एप्लीकेशन किसके पास रहने चाहिए, दैट विल डिसाइड बाय द कोर्ट और द कंट्रोलर. सो उनका जो भी फैसला होगा वो माना जाएगा इन केस ऑफ द डिस्प्यूट. ओके, सो आपका सेक्शन 20 का बोलिए.
मैम, इन दिस सेक्शन 20 how the MNC questions will be created?
MCQ क्वेश्चंस नहीं आएंगे इसमें. इसमें ट्रू एंड फॉल्स में क्वेश्चन आ सकता है, या तो फिर क्लाइंट एडवाइस वाले क्वेश्चन जो आपका डिस्क्रिप्टिव पेपर है उसमें इसके क्वेश्चन आ सकते हैं.
ओके
ओके, so what is the crux of 20? First says that before the grant of the application you can apply for the substitution of the applicant first by the assignment of the agreement. First says that and second, किसी और के consent के बिना आप किसी और का नाम डाल नहीं सकते. Third says that आप assignment जो भी करोगे उसमें तो you have to mention clearly over there कि कौन सा application के लिए you have applying for the substitution with the proper agreement and assignments. Now इस टाइम पे सपोज कुछ डिस्प्यूट है तो कोर्ट का डिसीजन फाइनल माना जाएगा. एंड सेकेंडली you have to submit amended form 1 also and the deed of assignment. Fourth, we have discussed this कि अगर any of the joint applicant for the patent is died, so at that time legal representative sorry जो भी लीगल रिप्रेजेंटेटिव है उसको एक डायरेक्शन दिया जाएगा, तो उसमें जो सर्वाइवर रहेंगे वो उनके बिहाफ में जो एप्लीकेंट अवेलेबल नहीं है उनके बिहाफ में वो काम करेंगे, मतलब वो पेटेंट को ओन करेंगे. एंड इन द फिफ्थ, दैट इज इन केस ऑफ एनी डिस्प्यूट बिटवीन द एप्लीकेंट्स, सो कोर्ट का डिसीजन और कंट्रोलर का डिसीजन आफ्टर द हियरिंग विल बी कंसिडर्ड. कि ऐसा नहीं है कि किसी एक को सुनेंगे और किसी और को नहीं सुनेंगे कंट्रोलर. दे विल हर्ट बोथ द पार्टीज एंड देन डिसाइड कि किसके केस में ये जाना चाहिए.
मैडम,
हाँ जी,
एक डाउट मैडम.
बोलिए ना.
Suppose there are 3 applicants A, B, C having a joint ownership of a patent.
हाँ.
If the person A dies, so B and C are the survivors. Okay. The patent will go to B and C, or the legal representative of A and B and C. That is the survivors plus the legal representative of A. How it is?
सपोज लेट्स से मैं आपका जो क्वेश्चन है उसको थोड़ा रिफ्रेम करूं कि A, B and C, that is 3 joint applicant and one is dies, right? So
A dies. For example, A dies.
Okay.
So B and C are the survivors.
Correct.
So the patent will go to B and C, or the legal representative of A plus B and C.
लीगल रिप्रेजेंटेटिव ऑफ ए एंड बी एंड सी, प्रोवाइडेड दैट कि आपके एग्रीमेंट में क्या मेंशन किया है. लीगल रिप्रेजेंटेटिव के बाद उन्होंने किसी और को अपने राइट्स दिए हुए हैं कि नहीं. जैसे हमारा ये नॉमिनीज रहते हैं, राइट, कि मेरा पीएफ है तो उसके नॉमिनीज में मैं मेरे कोई भी पर्सन का नाम डाल सकता हूँ. एट दैट टाइम आपने जो भी एग्रीमेंट किया है, सो ये एग्रीमेंट में क्लॉज मेंशन होना चाहिए कि सपोज एनी ऑफ द एप्लीकेंट इज डाइज, और इन केस ऑफ एनी तो कोई ओन करेगा या उनके राइट्स ये दोनों को ट्रांसफर हो जाएंगे. दैट डिपेंड्स कि आपने क्या आपका एग्रीमेंट में क्या मेंशन किया है.
What is the understanding? It depends on the understanding between A, B and C, right?
Correct. Done. So moving towards the section 21, time for putting application in order for grant.
Ma'am, one more thing in the section 20. If suppose the if suppose the inventor is one person and उसने अपने पूरे right assignee को दे दिए हैं. In this case, inventor में से कोई भी एक disease मतलब death हो जाती है. In this case, what will happen? कुछ नहीं होगा.
कुछ नहीं होगा ना, बिकॉज इन्वेंटर ने ऑलरेडी अपने राइट्स असाइनी को दे दिए है. इन्वेंटर से ट्रांसफर्ड द राइट्स टू द एप्लीकेंट और असाइनी.
ओके.
इन्वेंटर का कुछ राइट्स ही नहीं है यहाँ पे. रिमेंबर वन थिंग, एप्लीकेंट हैज और असाइनी हैज द ऑल द राइट्स ऑफ द पेटेंट. उसको सेल करे या कुछ भी कर सकता है और लाइसेंस दे कैन ऑथराइज्ड पर्सन. इन्वेंटर इज जस्ट डूइंग द इन्वेंशन एंड खत्म हो गया उसका वहां पे.
Okay.
So applicant has all the rights to own. Applicant owns the patent.
Okay. Ma'am, suppose there is one educational institute. Suppose I am working for the BHU and I am filing for the patent. तो ऐसी कंडीशन में असाइनी क्या BHU होता है?
हाँ, डिपेंड से एप्लीकेंट किसने रखा है, एप्लीकेंट का नाम में क्या रखा हुआ है. एप्लीकेंट के नाम में अगर आपका कॉलेज का नाम है और कोई भी एजुकेशन इंस्टीट्यूट या किसी का भी नाम है तो वो ओन करेगा ये पेटेंट.
ओके. इन दिस केस इन्वेंटर को कुछ नहीं मिलेगा.
नहीं, कुछ नहीं मिलेगा.
अच्छा, ठीक है. थैंक यू.
ओके. इन्वेंटर का सिर्फ नाम आएगा, सो इन्वेंटर कैन डिस्क्लोज दैट कि मैंने इतने इन्वेंशन किए हैं और आई हैव डिड दिस एंड दैट. सो इन्वेंटर इसका नाम इसी के लिए है. But the rights of the patent goes to the applicant only. अभी इन सम एक केस ऐसा है कि सपोज मैंने 2 बंदों को रखा हुआ है इन्वेंशन करने के लिए, राइट. मैं उसका सारा चीजें उनको प्रोवाइड कर रही हूँ, बस उनको उनका दिमाग लगाना है और वो इन्वेंशन करना है. इन दैट केस मैंने उनको फैसिलिटी प्रोवाइड किया है. बीइंग एन एप्लीकेंट आई हैव प्रोवाइडेड द फैसिलिटी टू डू परफॉर्म दैट इन्वेंशन एंड उनको पर्टिकुलर सैलरी दी है कि ये इन्वेंशन करने के लिए. ठीक है. तो मैं आई हैव मेंशन दैट नेम एज अ इन्वेंटर, बट मैं उनको एप्लीकेंट में कंसिडर नहीं करूंगी बिकॉज मैंने उनका शेयर उनको दे दिया है, उनका काम करने का शेयर।
अच्छा,
ठीक है,
ठीक है। तो वो इन्वेंटर को तो कुछ मिलने वाला नहीं है, रॉयल्टी नहीं मिलने वाली है।
कुछ नहीं मिलेगा, एप्लीकेंट को मिलेगा, सब एप्लीकेंट को पे जाएगा।
बट मैम इन्वेंटर और एप्लीकेंट के बीच में कोई ये नहीं होता है क्या, मतलब क्या बोलेंगे, कॉन्ट्रैक्ट
एग्रीमेंट
कर सकते हैं, like MOU, memorandum of understanding should be there
हाँ.
between the inventors and applicant companies, where before beginning this inventor creating the invention, they might have some agreement, like once it is found, if it sells, royalty or percentage, something like that, or fixed amount, they might say, okay,
fixed amount, yeah.
It's all between the, like what you say, employer and employee relationship, but the employer will own the rights similarly.
Right.
And one more thing also, when you're joining into the any corporate organization, so at the time of joining, they'll give the some signed document. In that there is a clause called whatever the invention and intellectual property created in the organization that belongs to the organization or belongs to.
Correct. That is
already for the institution also.
And ma'am, in case अगर हम inventors ने पहले किया हो everything filing and all, फिर अगर वो हम किसी कंपनी को दे देते हैं पेटेंट, उस केस में कैसे डील करते हैं?
That is the transfer of rights.
Okay.
आपने ट्रांसफर कर दिए वो, that is between you and that any company कि आपको कैसे डिसाइड करना है आपके राइट्स।
तो उस टाइम पे वो एप्लीकेंट हो जाएगा ना कंपनी?
because you are transferring your rights to that particular company.
So and will that be considered under assignment of rights, right?
Assignments of rights. You have assigned your application to the other party. Okay.
Ma'am, one more thing. Suppose ministry ने हमको एक project दिया, and that in that project I am working and my researchers also working. And उसकी PhD complete हो गई, वो he joined the another company and he has given he has disclosed the all invention there, and the company has patented. उस after that one, once the DST को मालूम पड़ा या फिर principal investigator knows this thing that this researcher has disclosed this one research, and उस कंपनी ने पेटेंट अगर फाइल कर दिया, तो क्या हम लोग अपना इन्फ्रिंजमेंट के लिए उसको सूट कर सकते हैं क्या?
So with the reasonable grounds like कि आपके पास उसका पूरा डाटा होना चाहिए, डॉक्यूमेंट्स होने चाहिए कि आपने उन्होंने क्या क्या काम किया है उस पे, that is mentioned in your record book or the ERP system. Look, this is the, so you can prove over that कि ये जो मैंने इन्वेंशन किया है और इन्होंने जो भी अप्लाई किया है और ग्रांट हुआ है, that is already existing before the priority date of the application.
Okay.
आपने जो भी एक सिनेरियो डिस्क्लोज किया ना कि बंदा यहाँ से छोड़ के दूसरी जगह पे चला गया और वहां पे उसने पेटेंट फाइल की, so in that scenario companies जितने भी R&Ds रिसर्च एंड डेवलपमेंट्स वाले हैं, जो भी बंदे हैं, उनके पास से एक एग्रीमेंट साइन करवाते हैं कि आप यहाँ से आप छोड़ के जा रहे हो, तब से लेके देयर इज सर्टेन टाइम लिमिट्स इज मेंशन्ड ओवर देयर कि 5 साल तक आप यहाँ का कोई भी डेटा वहां पे डिस्क्लोज नहीं कर सकते, और इन सम ऑफ द केसेस you should maintain the confidentiality कि आप यहाँ का कोई भी डेटा वहां पे डिस्क्लोज नहीं करेंगे, otherwise companies legally take an action to that particular person.
Right. Yeah, ये होता है, ये
हमारे साथ भी हुआ है।
एजुकेशनल इंस्टीट्यूट में ऐसा कुछ भी नहीं साइन कराते हैं वो लोग?
नहीं, एजुकेशनल इंस्टीट्यूट में नहीं होता है, बिकॉज
नहीं, बट उनके इसमें नॉर्म तो जरूर होता है, जो भी आईपी डेवलप होगा वो सारा इंस्टीट्यूट के नाम पे ही रहेगा, उसके कॉन्सिक्वेंसेस का आई डोंट नो।
पर वो प्रिंसिपल इन्वेस्टिगेटर ही साइन करता है, उसके अंडर में अगर जो 2-4 रिसर्चर रह रहे हैं उसमें से किसी ने ब्रीच ऑफ ट्रस्ट किया तो उसका क्या कर सकते हैं, मतलब ऐसी स्थिति में?
यूनिवर्सिटी की आईपीआर पॉलिसीज होती हैं, उसमें वो सारी कंडीशंस मेंशन्ड होती हैं।
मेंशन तो होती हैं, पर वो जो जेआरएफ आते हैं, एसआरएफ होते हैं, उनको उनका कोई साइन नहीं होते हैं सब पे।
मैम वो IPR पॉलिसी में होता है सब कुछ लिखा हुआ ना, उसमें वो सारे कवर हो जाते हैं.
They are sometimes made to file a non-confidential disclosure agreement.
Right.
So I remember that I also joined in such position as some project assistant. So I was made to sign some agreement that I should not disclose the information that I have with whatever it is. So in many cases we are like made sign some agreement. So company or institute takes care about this. Many institute, I think so, takes care of such things, and person also will, where there are very less chances that person will do such things, because there are always legal actions से ये रहता ही है हमेशा कि legally there could be some issues and like this.
Mr. Parak, what you say is applicable for hardcore research institutes. What you say is applicable for hardcore research institutions.
Correct.
But not for generalized institutions wherein they don't ask for non-disclosure agreement. They just academic interest only they are doing it. In case of academic interest only, these researchers are done, and these researchers, when they do for their PhDs or theses or anything like that, there is no need for signing any non-disclosure agreement. Okay.
But then I believe that those things would be published somewhere. I mean, the person who is doing some research now,
that's what I'm coming
so
to.
he will definitely go for publication or something.
Yeah, it will be published. In that case, it will come as a prior art to the examiner.
If you have applied for the patent, then it's considered as a prior art.
Yeah.
Or you can prove over that. Look, this is the prior art. The work is already has been done a few years back or a few months back, before the date of few years back. Yeah, before the date of the application. Okay. So I hope this is clear to everyone up to section 20. Now moving towards the section 21. That is time for putting application in order for a grant. You can say that this is the rejection tool. जितने भी grounds है mention किया है वो rejection tool में consider कर सकते हैं controller. So subsection 1 of the section 21 says that if you there is a two cases. If you unable to file your CS within the 12 months of time, then your application will be abandoned. And second case, if your FER has been issued for your application and you are unable to file the response within the 6 months, then also your application will be abandoned without the prior notice. Okay. An application for a patent shall be deemed to have been abandoned unless, within such period as may be prescribed, the applicant has complied with all the requirements imposed on him by or under this Act, whether in connection with the complete specification or otherwise in relation to the application, for the date on which the first statement of objection to the application or complete specification or other documents relating thereto is forwarded to the applicant by the controller. Sorry, कंट्रोलर ने कुछ भी आपके पास कम्युनिकेशन किया विद इन द प्रिस्क्राइब टाइम लिमिट, अगर आप उसको रिवर्ट बैक नहीं कर रहे हो या फिर आपको टाइम चाहिए तो आप टाइम एक्सटेंशन ऑफ टाइम के लिए भी अप्लाई नहीं कर रहे हो, रिक्वेस्ट नहीं कर रहे हो, इन दैट सिनेरियोज योर एप्लीकेशन क्लियरली अबेंडन्ड. Now the 2 says that if at the expiration of the period as prescribed in the subsection 1, an appeal to the High Court is pending in respect of the application for the patent for the main invention. Okay. And in case of an application for a patent of addition, an appeal to the High Court is pending in respect of either that application or the application for the main invention. The time within which the requirement of the controller shall be complied with shall on the application made by the applicant before the expiration of the period as prescribed in subsection 1 be extended until such date as the High Court may determine. Now, in that case, suppose High Court में main invention के लिए कोई भी अपील पेंडिंग हो रही है. Suppose let's say कि आपका जो मेन इन्वेंशन है उसको कॉन्टेस्ट किया है by way of infringement or the like the opposition, right? So at that time पहले क्या था, IPAB में आपका मैटर जाता था, IPAB उसको फिगर आउट करके वो मैटर हाई कोर्ट में ट्रांसफर होता था, राइट? सो इन दैट सिनेरियो कंट्रोलर डायरेक्टली डिसीजन नहीं देगा आपकी कोई भी एप्लीकेशन होगी तो. उसका मेन इन्वेंशन पे सपोज कुछ फाइल हुआ है इन केस ऑफ पेटेंट ऑफ एडिशन, राइट? सो मेन इन्वेंशन पे कुछ क्लेम हुआ है और आपका पेटेंट ऑफ एडिशन लास्ट डेट पे है कि वो ग्रांट करना है कि नहीं करना है, लाइक आपका हियरिंग कंप्लीट हो गया, सब हो गया है. बट इन दैट सिनेरियो कंट्रोलर विल नॉट डू एनी डिसीजन आप जब तक आपका जो एक मेन इन्वेंशन का रिजल्ट नहीं आ जाता, कि उसका कुछ डिसीजन नहीं आ जाता, राइट?
Any litigation pending, right?
एनी लिटिगेशन पेंडिंग होगा कोई भी एप्लीकेशन पे तो कंट्रोलर एप्लीकेशन का डिसीजन नहीं देंगे.
इन दिस केस मैम प्रायर आर्ट का क्या होगा?
सॉरी
मैम, इस केस में प्रायर आर्ट का क्या होगा? सपोज इस पूरे ड्यूरेशन में कुछ और इन्वेंशंस आ गई.
प्रायर आर्ट विल कंसीडर बिफोर द फाइलिंग ऑफ योर प्रायोरिटी डेट ना, नॉट आफ्टर द प्रायोरिटी डेट.
ओके, ठीक.
So please say any question? I think he says that hello, is there any question?
वो निकल आती है ओट, जीता है तो किसी ओट निकल जाती है.
Please mute your mic. 3 says that if the time within which the appeal mentioned in subsection 2 may be instituted has not expired, the controller may extend the period as prescribed under subsection 1 to such further period as he determined, provided that if an appeal has been filed during the said further period and the High Court has granted any extension of time for complying with the requirements of the controller, then the requirement may be complied with within the time granted by the court. अभी सपोज कि आपने एक्सटेंशन के लिए अप्लाई किया हुआ है किसी के लिए किसी एप्लीकेशन के लिए, लाइक आपका CPS के बाद CS you are not able to file in 12 months, so you have extended that deadlines or timelines, right? At that time controller wait करेंगे कि वो prescribed time complete होने का. और in the case कि जब हाई कोर्ट ने किसी एक्सटेंशन के लिए अप्लाई एक्सटेंशन ऑफ टाइम दिया हुआ है कोई भी एप्लीकेशन को, सो एट दैट टाइम आल्सो जितना भी टाइम दिया हुआ है हाई कोर्ट ने उस टाइम के बाद उसका डिसीजन के लिए जाएंगे एप्लीकेशन पे. ओके, सो हम इसका क्रक्स देखें तो पहला कि if you are unable to comply the requirements of the controller within the prescribed time, then your application will be abandoned. Secondly, in case of any dispute, आपके एप्लीकेशन का डिसीजन नहीं आएगा फॉर द पेटेंट ऑफ एडिशन जो भी आपने फाइल किया है, बिकॉज आपकी पेरेंट एप्लीकेशन पे ही कुछ क्लेम हुआ है. एंड थर्ड जो है, the court permit the time to the controller for wait for the particular applicant to comply the all the requirements.
मैम इस पे क्वेश्चन किस तरह से पुट अप हो सकते हैं?
किस पे? इस पे क्वेश्चन मैंने अभी तक देखा नहीं है. इस पे क्वेश्चन मैंने जितने भी पेपर स्टडी किए ना उसमें So इस पे questions ये हो सकता है कि what is the ground like they can simply ask you that what is the section 21, which is the time for putting application in order for grant. So what is the clauses for that?
Okay, और केस स्टडी पे भी कुछ हो सकता है क्या?
ये हो सकता है कि सपोज कोई एप्लीकेंट आपके पास आया है कि मेरी एप्लीकेशन का लाइक अभी तक डिसीजन नहीं आया है, सो आप उसको कैसे गाइड करेंगे? सो इन द और एनी एप्लीकेंट आस्क यू दैट कि मेरी एप्लीकेशन अबंडन हो गई है, सो व्हाई दिस, सो कि मुझे कोई प्रायर नोटिस नहीं दिया और मेरी एप्लीकेशन अबंडन हो गई है. सो यू कैन एक्सप्लेन सेक्शन 21 सबसेक्शन 1 इन दैट सिनेरियो.
Okay.
Madam, I got the IPAB, Intellectual Appellate Board. It's dissolved by the Government of India, and any refusal of action, if you want to take by the controller, so the applicant has to go directly to the High Court. So Appellate Board is get dissolved by the government, ma'am?
Yes, it is dissolved by the government, but they have we have not received any guidelines for that yet. कि आपको कैसे प्रोसीड करना है. सो अभी भी जितनी भी एपेलेट बोर्ड में जितनी एप्लीकेशन की है वो एज इज है, अभी उसका कुछ भी आया नहीं है, मैटर्स क्लोज नहीं किए वहाँ पे.
मैम वो जो एक दिल्ली हाई कोर्ट का आईपी डिवीजन जो हुआ है, रिप्लेस किया है जिसने आईपीएबी का, तो वहाँ पे अपील कर सकते हैं ना?
मुझे चेक करना पड़ेगा. आई एम नॉट अवेयर अबाउट दिस.
ओह, केसेस ट्रांसफर नहीं हुआ क्या वहाँ पे?
In my understanding, basically, even though they said that this has to be dealt with the High Court, there are logistical or practical difficulties in deciding the technical judges for this kind of matters. So that might be kind of a discussion happening. A new board might be set up, like appellate board. It's like a separate court for dealing with this matter. I'm not sure about it. In fact, I asked the other instructor thing. So probably it has to evolve. We need to wait and see any information is coming up.
Yes.
Correct. So you're right. It could be the combination of a legal person and also technical skill experience.
Yeah, basically in courts, civil courts are mostly they don't have much of technical expertise, and mostly they all the judges will be on roll. Like they will be every 3 months they will be on roller coaster. So no specific judge handles specific matters, but these all are like chemical domain, chemical technical judges required. So there will be a lot of practical difficulties. Probably will be a new complete setup will be coming up. I think it looks like it's not yet evolved.
So let's wait for the decisions. ये क्या आ रहा है उसका. Meanwhile हम आज एक numbering system आपका बाकी है ना? Have you learned the numbering system?
No, ma'am, not yet. I think
not yet, no? Okay, so I will cover in this. It will take hardly 10 to 15 minutes. So that is under rule 37, that numbering of application. So numbering system kaise hai? You are aware about the format, right? So basically first 4 digit denotes that the year of filing. Then the next digit, that is the 5th digit, आपका jurisdiction बताएगा. Jurisdiction is like first is for the Delhi, second is for the Mumbai, third is for the Kolkata, fourth is for the Chennai. T shows the type of the application. There is a 9 type of application. That is basically there is a 3 type of application, but it is subdivided into the divisional and the patent of addition, right? So ordinary application, conventional application, and national phase application, that is PCT application. That is further subdivided into the divisional application and patent of addition. So type of application is like 1, 2, 3, 4, 1 to 9. For this the ordinary application, then ordinary to divisional, ordinary to the patent of addition, right? And followed by the 6th digit of the serial number, that is the NNN. So you have to remember this format also. So here is the example. It's like if for one ordinary application filed in the Delhi in 2020, so what would be the number of that application? first is the year 2020, ordinary application. Next is the jurisdiction. So 1 is the jurisdiction for the Delhi. So jurisdiction 1. Then again 1 is the ordinary number, ordinary for the ordinary application, and followed by the 6-digit serial numbers. Okay. If the conventional application is filed in the Mumbai, then what would be the case?
2.
Conventional application is number 4. So 2020 would be the year. 2 is the jurisdiction, that is in the Mumbai. 4 is for the conventional application, followed by the 6-digit number, that is the serial number. Now, hope this is clear to everyone. Is there any question or confusion?
Fine now.
It's fine, no? Okay. Now, what is the format for the request for examination? उसमें suffix r लग जाएगा और कुछ नहीं, change नहीं है इसमें. और in case of expedited examination, उसमें आगे x लग जाएगा. X denotes that is the expedited examination. And the particular serial number, कि आपका year of application क्या है, आपने जब apply किया examination के लिए, sorry, वो क्या है, कौन से jurisdiction में आपने apply किया, कि आप apply तो करोगे 1, 2, 3, 4 में से ही करोगे, जहां आपने application file की है. At that office you have to apply for the request for examination. So from the Mumbai division, so that is a J and followed by the serial number. कि जो भी आपका उस टाइम पे सीरियल नंबर होगा वो कंसिडर किया जाएगा. ठीक है. And the X similar way X denotes for the expedited examination. The rule 11 says that order for recording the application. The application filed in a year shall constitute a series identified by the year of such filing. In case of an application filed corresponding to an international application in which India is designated, such application shall constitute a series distinct from the rest of the application identified by the year of filing of corresponding application in the India. सपोज फॉरेन एप्लीकेशन इंडिया में फाइल होती है, उसका भी सिमिलर नंबर रहेगा हमारा जो है, बट उसकी सीरीज जो डिनोट होगी, मतलब विच टाइप ऑफ एप्लीकेशन इज दैट, वो एप्लीकेशन का नंबर, टाइप ऑफ द एप्लीकेशन इज मेंशन इन द सीरियल नंबर. सो उससे वो डिफरेंशिएट होगी. सो नंबरिंग ऑफ द एप्लीकेंट आयंस ऑन द ग्रांट ऑफ द पेटेंट. अगर पेटेंट कोई भी ग्रांट है इंडिया में, वो कैसे पता चलेगा? The particular there is a 6-digit of the series number is there for the any granted application. So what is the ordinary application? An application which has been filed directly in the Indian Patent Office without claiming priority of any foreign application. जो हम इंडिया में डायरेक्टली फाइल कर रहे हैं, that is our ordinary application. Now, what is the conventional application? That claiming the priority of the country which is a member of the Paris Convention. कि आपने डायरेक्टली कंप्लीट स्पेसिफिकेशन फाइल किया है और किसी और कंट्री में से आपको कंप्लीट स्पेसिफिकेशन इंडिया में फाइल हुआ है डायरेक्टली. दैट इज अ कन्वेंशनल एप्लीकेशन. दैट इज नॉट that is claiming the priority of the country which is the member of the Paris Convention. Now PCT application, you all are aware about it. Divisional application, that is a further application divided out of the first mentioned patent application that is discussed in the section 16. Now what is a patent of addition? That is an application for a patent in respect of an improvement in or modification of the invention for which the patent application has been already filed or patent has been granted. So
madam, one doubt madam.
बोलिए.
Among the three, ordinary, convention and PCT, which is better for the patent applicant?
File the ordinary application.
Okay.
Right. और फॉर द कन्वेंशनल एप्लीकेशन इज लाइक कि आपको अगर 2 या 3 कंट्री में ही फाइल करनी है, but not more than 2 or 3 countries. So I would suggest कि directly file for that particular countries. Okay. And PCT आपको more than 3 countries में फाइल करनी है या more than 2 countries में फाइल करनी है कोई भी एप्लीकेशन, provided that कि कॉस्ट कितना हो रहा है आपकी वो पर्टिकुलर कंट्रीज का, तो उसके बाद आई सजेस्ट कि PCT में फाइल करिए एंड देन फर्दर गोज टू द अदर कंट्रीज. ओके, डन. ये नेक्स्ट आपका बाद में आएगा. Is there any doubt in this?
Ma'am, is it necessary we need to understand about, understand about US patent application numbers? Basically, we look at a lot of references prior arts. So they call it as, B1, BA, A1 like that. So,
that is called as a kind code. Kind code से आपको पता चल जाएगा कि ये एप्लीकेशन ग्रांट है कि नहीं है. In the US आपका अगर A1 है, so that is a published application, and B1 है, that is a grant application, right?
Okay.
Now you can look out for the series of number patent application series in Europe. So Europe में आपका एक ही नंबर रहता है from the filing to the grant, but उसके kind code change होता है.
Okay.
So
Europe में अगर we need to learn about this, madam, like in the examination? No, not
no. It is not in the India. So India में जो है वही हमें करना है.
Right.
Okay. Done. We are done with the today's session. Any doubt or any question?
Excuse me, ma'am.
Yes.
Ma'am, do you have some notes related to the prescribed time limits and all?
See, there is a
notes related to.
I can say that कि मैंने जब प्रिपरेशन की थी तो मैंने पेटेंट एक्ट के साथ पेटेंट का जो मेरा बुक है उसमें ही मैंने टाइम लिमिट्स लिखी हुई थी. सो हम लोग उसको अलग से याद रखने की जरूरत नहीं है कि आपको अलग से नोट्स बनाइए कि ये सेक्शन की ये टाइमलाइंस है. सो इट इज बेटर टू राइट विद दैट पर्टिकुलर सेक्शन. डायरेक्ट में ही आप लिखिए वो चीज. ये आपको बेनिफिट रहेगा जब आप रिवीजन करोगे, तब भी बेनिफिट रहेगा. और जैसे कि मैं अभी आपको समझा रही हूँ, पढ़ा रही हूँ, तो उस टाइम पे मेरे लिए भी बेनिफिट है. बाय लुकिंग एट माय बुक मैं आपको इजीली बता पाऊंगी कि यहाँ पे ओके दिस इज द मेन पॉइंट, दिस इज द इम्पोर्टेंट पॉइंट व्हिच आई ऑलरेडी मेंशन्ड इन माय बुक एट द टाइम ऑफ प्रिपरेशन.
मैम ये बहुत सारी चीजें ऐसी हैं उनको मेमोराइज करना काफी डिफिकल्ट है. कोई ट्रिक्स आपने यूज की थी?
So for that you have to remember all the sections daily. मतलब मैंने आज अभी तक हम 21 सेक्शन तक कंप्लीट किया है. ठीक है.
हाँ जी मैम.
So किसी की आदत होगी ड्राइविंग करते वक्त म्यूजिक सुनना, किसी की हैबिट होगी मॉर्निंग वॉक की. So at that time record your own voice and you have to listen that. So for this 4 months आप जब भी बैठे हो, कुछ भी कर रहे हो, वो सेक्शंस आपके पास होने चाहिए.
Right, ma'am.
Then only you can able to remember because it's the law, so it is really difficult. But practice it daily. Like अभी भी हमें जब भी कोई पूछते हैं कि सेक्शन 16 क्या कह रहा है, तो हम बोलेंगे वो डिविजनल के बारे में बात कर रहा है. So
मैम इट इज ओके अबाउट सेक्शंस. अभी जैसे आपने बोला सेक्शन 16 डिनोट्स डिविजनल एप्लीकेशन, बट उसमें जो सब सेक्शंस है वो याद रखना बहुत डिफिकल्ट है. मतलब 16(1), 16(2) बाप रे, मतलब कैसे.
So आपको वो सब डिटेल में याद रखने की जरूरत नहीं है. आपको समझना पड़ेगा कि ओके डिविजनल एप्लीकेशन में क्या क्या बात कर रहे हैं और कौन कौन से पॉइंट है. जैसे मैंने अभी सेक्शन 20 का आपको बताया कि एक में ये बोल रहे हैं कि ये नहीं हो सकता, सेकंड में इन्फ्रिंजमेंट कैसे हो सकता है. सो यू हैव टू रिमेम्बर इन योर ओन लैंग्वेज. आपको ये कंप्लीट लिखना नहीं है वहां पे. कोई आपको ये नहीं बोलेगा कि सेक्शन 20 का 1 और सबसेक्शन 2 आपको मेंशन करिए, बट यू हैव टू रिमेम्बर द क्रक्स ऑफ द पर्टिकुलर सेक्शन कि ओके इसमें ये है, उसमें ये है.
ओके मैम हो सकता है ये सबसेक्शंस वगैरह वाइवा के टाइम पे पूछेंगे।
सबसेक्शंस नहीं पूछते हैं वो, उनको भी पता है, याद नहीं रहता।
मैम यूजुअली कैसे रहता है वाइवा का?
वाइवाज आर लाइक कि पहले तो डिपेंड करता है कि कौन आ रहा है आपके सामने वाइवा लेने के लिए। डेफिनेटली कंट्रोलर्स होंगे या एग्जामिनर्स होंगे। सो मैं मेरा एक्सपीरियंस शेयर करूं तो मेरा वाइवाज में जैसे हम कॉलेज टाइम पे वाइवाज देते हैं कि आपका एक क्वेश्चन लिया और उसके बाद उसको खींचते चले जाएंगे। मेरा वाइवा आई स्टिल रिमेम्बर कि हम बहुत प्रिपरेशन करके गए थे, अरे क्या पूछेंगे क्या पूछेंगे क्या पूछेंगे। सो मेरे वाइवा में जाके पहला क्वेश्चन है कि आप एप्लीकेशन कैसे फाइल करोगे, हाउ डू यू फाइल योर एप्लीकेशन एंड विच फॉर्म इज रिक्वायर्ड फॉर दैट। सो आई एक्सप्लेन द फॉर्म 1, फॉर्म 5, फॉर्म 2 लाइकवाइज। और उसके बाद वो वाइवास खींचते रहे, मतलब उनको फॉर्म्स और उन पे क्वेश्चन करने थे। सो दैट लाइक 20 मिनट्स तक वही चला।
तो मैम फॉर्म्स का जैसे आपने बोला, सो अपने को हर एक उसमें का भी क्लॉज देखना पड़ता है क्या?
हाँ, यू हैव टू रिमेम्बर दैट आल्सो कि अगर फॉर्म 1 है तो वो किस कौन से सेक्शंस के लिए जाएगा और उसकी फीस क्या रहेगी। सो मेनली आपका सेक्शंस और सबसेक्शंस जो है फॉर्म्स की याद रखने जरूरी है पहले तो।
ओके।
कि सपोज मैं एप्लीकेशन फॉर पेटेंट कर रहे हैं, वो मेरा कौन से उसमें जाएगा, सेक्शन में फॉल होगा और उसकी फीस क्या रहेगी। 3 सेक्शन में जाता है वो, 754 एंड 135। मैंने फॉर्म 1 की बात की, मैंने फॉर्म 1 का फॉर्म 1। ओके।
In my just like opinion, like these laws mostly in practice there will be only particular sections on daily practice. Though pattern
daily
book,
practice.
Yeah, so daily practice there will be only around 20-30 sections which will be normally used. So the good way to go around is to do a simulation kind of thing or group discussion. So one way is like you start from the forms, that form which section it comes there. So that section leads to which other objection section. So like that, it is a down way, one way. I think it is a one way it can do it. Because I remember this in trademark, we do that. So there are several sections, section 9, section 7, section 135, 134, 133. These are all the most relevant sections we use, or section 33 like that. So most of the sections are only supporting sections, but these all are based on the forms. So once we are familiar with the forms, and then rules and sections will cover there. Those will have a dependent sections where objections will be raised or like that. I think that way simulation would be a good idea.
That is the one way, and better to discuss with the friends or like families कि नहीं आपको सुनना पड़ेगा, बैठो मैं आपको सुना रही हूँ, like so better to discuss with the friends कि आपका जो भी preparation कर रहे हैं patent agent के लिए, so randomly ask numbers like section 43 that is talking about grant of patent. So ऐसे याद रहते ही चीजें.
Madam, one question, madam. This abstract, necessarily it has to be 150 words or even less than that?
Maximum 150 words, not more than that.
Okay. What is the minimum we can have?
Sorry? Minimum that is one liner. आप 10 words में भी डाल सकते हो.
Okay.
But your abstract describes the summary of your invention and the technical enhancement. By looking at the abstract, one can easily understand what your invention is talking about. So it is better to draft abstract such a way that कि वो easily समझ पाए कोई भी उसको पढ़ के कि crux क्या है वो. The invention abstract describes the crux of your invention. Okay. So अगर आपने एक वन लाइनर भी ड्राफ्ट किया है तो at the time of examiner, controller will raise the objection that you have to like amend your abstract.
Okay.
अभी one question is there. हमने amendment पढ़ा. So amendment में ये कहा कि आपको फीस पे करनी पड़ेगी for the any type of amendments. But what if अगर कंट्रोलर हमें बोल रहे हैं कि amendment करना है आपको ये, so क्या करना पड़ेगा?
See, this is just answering the objections, right? So there is no fee involved. No fee involved.
Yes. Correct. There is no fees and no forms involved because we are doing the amendment with the controller's guideline.
Exactly.
Okay.
I'm just asking to the team, the group which they are practicing it, and their daily how they are memorizing the section rules. If the team can share the best practice which they followed to memorize and for preparing for the exam, is there any best approach the people have used it?
As ma'am told that according to the form, we have to just memorize the sections and rules. This is the only the pill we can follow.
Okay.
Best practice is remembering the things as like daily practice.
Okay.
There is no escape, Shantanu.
Okay.
You have to go through the grind.
Okay.
वो उठ के या सोने से पहले you have to remember जितना sections आपने किया है, divide your sections in a particular group. कि मैं 1 से लेके 24 तक 21 तक आज मैं कर रही हूँ, तो मैं नेक्स्ट उसको एडिशन करेंगे कितने तक कर सकते हैं. That depends on you कि आप कितने तक का एक साथ में ले सकते हैं. तो divide your complete act in the particular sections. कि मैंने 1 to 24 आज कवर किया है, तो मैं 25 से लेके 53 तक कल कर लूंगी. तो वो चीज आपको जब तक वो 53 तक याद ना रहे तब तक आपको आगे नहीं बढ़ना है. So that is the only way.
Ma'am, I have a question. Ma'am, supposingly, if an application was under the secrecy direction and the time period of publishing, that is 18-month period, is over, and in 16th month the secrecy direction has been revoked, so what is the time period within which it will be published? Is there any timeline for that?
Yes, your application will be published after the next 6 months when your secrecy direction is revoked.
Okay, after the 6 months from the date of revocation.
Ideally, आप secrecy direction में ये देखेंगे, तो उसमें mention किया है कि it will be published in 18 months if your the secrecy direction is revoked, or within the next 6 months after the revocation of the secrecy direction.
Okay, ma'am. Thank you, ma'am. Ma'am, and one more question. Supposingly, if an invention is related to biotechnology field, and there are nucleotide sequences in that invention, so how do we insert those nucleotide sequence in our specification?
Somebody please can you repeat your question, please?
Sorry, ma'am.
Question सुनाई नहीं दिया, there is some network issue.
Okay, ma'am. I'm repeating. Supposingly, an invention is related to biotechnology field, and in that invention there are nucleotide sequences. So how do we insert those nucleotide sequences? How do we mention them in our specification? We need to write all the sequences.
That means you are talking about your biological material is involved in your application, and secrecy direction is imposed in your application, right?
No, ma'am. Supposingly, I'm using a gene, and I have to mention the nucleotide sequences like AGCT, जो nucleotide sequences होती हैं. So how do I insert those sequences in my specification?
There is a sequence listing, I think, but sequence listing is for the chemical related inventions only.
Okay.
I have to check this. Gene related applications. I will get back to you on this. Sure.
Okay, ma'am. Thank you, ma'am.
Okay. Any questions?
Thank you, ma'am.
Okay.
And happy New Year once again.
Happy New Year. Enjoy the New Year.
Thank you, ma'am.
Happy New Year,
Thank you,
ma'am.
ma'am.
Happy New Year to all of you.
Thank you. Thank you.
Yes,
Thank
Happy
you.
New Year
Same
all.
to you.
Happy New Year to all.
Happy New Year.
Chandra.